This is 10 questions. I'm Andy Johnson. There appears to be a ton load of questions arising from this issue involving the former Attorney General and a King's Counsel in a matter of allegations of corruption in the last administration. The allegations are to the effect that the former Attorney General, Anand Ram Logan, was involved in bribery, in seeking kickbacks for the distribution of state briefs to Queen's Counsel, now a King's Counsel. That person is Mr. Nelson. His surname is Nelson. We get into that point. What is the issue and what are some of the questions behind it? From the reporting over the last several days, one of the questions that is jumping out for a response, it appears to be that Mr. Nelson is the one who approached Mr. Ram Logan as Attorney General to say, look, I have something that I can tell you. I've been involved in cases for the state and I've been asked to give a kickback for it, and this is the situation. I'm telling you about it. Is that what transpired? My guest, try and understand some of that, Attorney Farid Ali. Good to see you. Thanks for coming on.
Good morning, Mr. Johnson. It's a pleasure to be here and to assist in any way that I can, if I can.
Yeah. So let's go for that question. It appears, can we establish that from the reporting thus far, it appears that it is Mr. Nelson who went to Mr. Ram Logan as Attorney General and said, look, I have something to tell you. I've been doing work for the state. In fact, he went to Mr. Al-Rawi and said, I've been doing work for the state and this is what has transpired. I had to give a kickback to the Attorney General then at the time, and matters sort of mushroomed from there. Is that fair to assume that, to conclude that?
Well, we ought not. I mean, we, the public, cannot comment on what factually triggered the corruption charges being laid against Mr. Nelson, Mr. Ramdeen, and Mr. Ram Logan. That has not been put in the public space. In the editorial carried in the newspaper, such was hinted, but there has been no official declaration by the Office of the Attorney General, nor has the Office of the Director of Public Prosecution stated who made the approach first.
Yeah.
So if it is indeed, it is being said that Mr. Nelson approached the Attorney General or the Office of the Attorney General, saying that he offered a kickback. For him to offer a kickback, it means to say that a state brief would have been offered to him in the first place.
Yes.
And perhaps one can infer that if a kickback featured in that discussion in terms of the state brief going to Mr. Nelson, and he must send money in the other direction as a result of receiving the state brief, then whether the author of that kickback or the person who asked for the kickback was somebody arising out of, or a situation arising out of the Office of the Attorney General back then. Simply put it in very finite language, if it is Mr. Ram Logan is asking for a kickback in order to send the state brief to Mr. Vincent Nelson, and Mr. Nelson receives the brief and is placed in the onerous position now where he's being in some way solicited or forced or approached with regard to giving something in return, he is free to go to the Director of Public Prosecution's office so to make a report at any point moving forward.
Right, I want to get to that.
I
want to get to that,
Yes.
the part of the involvement or the non-involvement of the DPP, but because that is a major feature in the thing as to how the charges may have been proffered, how they were put together, how they were constructed, because there is narrative in the reporting over the last couple of days on this. At a point early in the game, the DPP was saying to the Attorney General then, leave me out of that, I'm not going to get involved in that. But before we go there, the question is, so the matter was entered. There was a discussion apparently between Mr. Ram Logan as Attorney General and Mr. Nelson as somebody working for the state. It could have been that he would have been given briefs, and during the course of that process, he may have been approached and said, well, okay, if you're getting these briefs, this is what has to happen. We have to get this back or what have you. But the other question is, what we know now as to where the matter is, it appears as though somewhere to this point, the indemnity agreement that was arrived at seems to be in jeopardy, and Mr. Nelson is saying, I'm not going to go forward unless I have it ironclad that this indemnity agreement, some of the details we have seen, remains solid. Where is the sense that the indemnity is in any danger of being repudiated?
All right. Mr. Nelson is saying that he entered a plea of guilty, and what happened is the state offered immunity in exchange for him offering evidence or providing evidence against Mr. Ramlogan and Mr. Ramdeen. That is standard procedure. He would have pled guilty. He would have appeared before a high court judge. A plea agreement would have been signed, and the plea agreement is that it would have been the DPP offering to the Mr. Nelson immunity from further prosecution, or offering him to be, in this instance, the benefit of being placed on a bond for 3 years to keep the peace, in exchange for the evidence he's going to offer. Now, very skillfully and succinctly, Mr. Nelson included in that arrangement certain conditions by which he will offer the evidence, and one of the conditions was, and is contained in what we call, is packaged in the indemnity agreement, which is the subject of contention now. Very smartly, Mr. Nelson is saying, I will offer the evidence, but you must meet certain criteria. You must meet certain conditions. One of the conditions would have been that the facts arising out of this charge that was laid against me would not be made public. It would not be made available in terms of the public space. No police investigator who would have investigated this matter can offer this information beyond the fabric of the courtroom.
So that is the substance of his concern now, that somehow the matter is going to become become in the public domain, and he was protesting against that and saying, if that happens, then I'm pulling out.
Well, there are other elements. That is one of them. Another element is that the information arising out of the charge being laid, meaning the facts surrounding it, that factual matrix will not be made available to any foreign disciplinary body. Remember, he's a practicing attorney. He has been called to the bar to practice in Trinidad. He's a Queen's Counsel, in this case, by now a King's Counsel. And if it is the disciplinary body or any disciplinary body that accredits Mr. Nelson to practice professionally in any particular way, is aware that of the facts surrounding these allegations and this conviction against him, and why it is the state offered the immunity, they may still act on that information and take action against him outside of Trinidad and Tobago. So he was protecting himself. So that's a second issue that would have formed part of the indemnity arrangements. Also, there's a financial issue where certain monies ought to be paid to him to indemnify him and so on.
Right.
One of the other criteria is that the state was paying for his legal representation.
Yes.
So clearly, the indemnity package contains several prongs, and one of the prongs includes, well, each of the prongs is equally as important as the other.
That's the other.
He is saying that the state did not deliver and did not act on or fulfill its obligation with regard to the indemnity arrangement, and therefore, if it is he's to offer evidence, he's not offering any evidence until they fulfill that arrangement. Clearly, the state has forfeited, or the state was delinquent in not fulfilling the arrangements or the conditions in the indemnity arrangement.
Right.
Now, he is saying...
Go ahead.
He's saying he's not going to... This is not a situation where the witness is saying that he will never offer the evidence. He's saying, I will offer the evidence, but fulfill the conditions of the indemnity arrangement. Now, if the DPP's position is this, he cannot be held to ransom by Mr. Nelson. He cannot be held to ransom by a witness. He has a separate, free and distinct matter to deal with before the criminal courts. The DPP, the office of Mr. Gaspard, must now go to the magistrate's court and indicate, listen, my key witness is not in a position to offer evidence in this moment, and it does not appear that he will be offering evidence, or he may be in a position to offer evidence in the foreseeable future.
Right. So isn't that what he's done? Yeah, isn't that what he has done effectively? And I want to ask about at what point did he get involved in the matter? If it is being established that the then Attorney General Al-Rawi went ahead on his own to proffer these charges and to build the case to go to court, without respect to... Al-Rawi
couldn't lay the charge. Al-Rawi would have gathered the information and supplement and put the file in the hands of the director of the police the police would have prepared a file, investigated the matter, and they would have submitted a file to the Director of Public Prosecution's office. So the chain of command would be, information came to Alwari, Alwari prepared a file, informed the police, in this case it would have been the Commissioner of Police, then the Commissioner of Police would have had an investigative team examining the facts surrounding this, then the police service, the unit that investigated these men would have sent a file to Mr. Gaspard, and Mr. Gaspard would have acted on the file. Mr. Gaspard has a responsibility to examine the file and to make a determination as to whether he thinks charges ought to be laid and the nature of the charge. Mr. Gaspard preferred charges under the Prevention of Corruption Act, Section 3 and Section 5 of Section 45 of the Proceeds of Crime Act.
Yeah, but what is the point at which, and what is the issue over which the DPP was saying, and it's in some of these pieces of correspondence, they're saying to the then Attorney General, do not pollute the sanctity of my office by asking me to do this or that or the other. That is on the record.
Right. The DPP cannot take instructions from the Office of the Attorney General. The Office of the Attorney General is separate and apart from it's the legal body that advises the cabinet and the government as to how they should proceed, and it also acts as the legal body for the parliament, so to speak. In other words, it would be the Director of Public Prosecution's office is free, separate, and distinct from, and it's an apolitical body, meaning it cannot be influenced by any politicians. Now, under Gary Griffith, the Anti-Corruption Investigation Bureau came under the ambit of the DPP's office. So, in other words, the DPP would have had the benefit of the investigative material derived out of the Anti-Corruption Investigation Bureau. When the DPP acts on the information they get from that organization or that unit, then they could prefer charges. The DPP, under the Constitution of Trinidad and Tobago, has the power to proceed with a charge, discontinue a charge. So, in other words, the Attorney General has no say. He has no influence over what happens at the DPP's office. It is two separate and distinct bodies altogether. So Mr. Alwari cannot advise Mr. Gaspard. He cannot in any way interact with Mr. Gaspard, because for all intents and purposes, Mr. Alwari is a witness to these proceedings. So Mr. Gaspard, unless it is Mr. Gaspard needs to speak to Mr. Alwari with regard to his statement and the evidence he intends to offer in the trial moving forward, there is no reason why a witness for the state could be advising the DPP with regard to how to proceed.
So what is the basis?
Simply an instrument of the DPP's office in this instance.
What is the basis on which, and what is the issue over which people are now hailing what they see as the shining example of integrity by the DPP in refusing to do certain things?
Right. The DPP did the honorable thing in withdrawing the charges against Mr. Ramdeen and Mr. Ramlogan, because its function is to either proceed with a prosecution if there is evidence and if there are available witnesses, or desist from proceeding, discontinue the matter if he's of the view that there is not enough evidence in this moment that he can offer, and there is not an available witness that he can. What the DPP said is he cannot sit back and wait until the indemnity suit that Mr. Vincent Nelton brought against the Office of the Attorney General has been completed, and then a decision made then before he can offer his witness. In other words, Mr. Nelson has held the state to ransom. He's held the criminal proceedings to ransom. He's saying that I will not be offering the evidence until it is they pay me, or until it is they fulfill the conditions of the indemnity arrangement at the High Court. That matter has not been ventilated before the High Court as yet. So the DPP is saying, I cannot sit back and wait until that matter has been completed at the High Court, because where we are is the Chief Magistrate, Cadel Earl Busby, is simply stating that the state is ready to proceed at the preliminary inquiry against these two men, Ramdeen and Ramlogan, and they're ready to proceed, and she is not prepared at this stage to stall the matter any further. So the DPP is caught between a rock and a hard place. Yeah. He cannot tell the magistrate's court, when the preliminary inquiry is on the cusp of starting, that he wants to delay the matter indefinitely without any time frame involved until the matter is settled at the High Court. She will simply indicate, I have a matter to start here.
Right.
If it is you don't have a witness in this moment, then withdraw it, and then you could relay the charge down the road.
What is your interpretation?
Nothing prevents it from relaying charge.
What is your interpretation of the response of the current Attorney General, who says that he is surprised and shocked at what has happened? And some people, from my reading of it, suggest that he's surprised and shocked by the fact that the the DPP has vacated the case, or is he surprised and shocked that at the fact that Mr. Nelson has decided not to go forward? And then he tacks on to that not to move away from it entirely yet, because he's going to try and find a means by which, if at all possible, that this case could go forward.
Well, I think the current DPP has already had his name passed in a certain direction.
I mean, the current AG.
If I may put it this way. Yes, sorry. The current Attorney General, Mr. Amor, has already had so many questions asked of him in his short term in office that he very skillfully wants to distance himself from any fiasco arising out of that arrangement Mr. Alrawi had with Mr. Vincent Nelson. He's clearly stating that he was not in office at the time that is Mr. Alwari entered into that agreement with Mr. Nelson and so on. And well, when I say he entered, he was part of the arrangement. The DPP would have entered that arrangement with Mr. Nelson. And very succinctly, the position would simply be that Mr. Alwari is saying that he entered into the indemnity arrangement after consulting senior counsel Gilbert Peterson and
Douglas
Mendez. So the hot coals that was thrown on the current AG's lap, he doesn't want that hot coals on his lap. He doesn't want to be associated with another controversy surrounding his office and himself. So he's simply indicating that he's shocked that that is the position. His shock could have arisen out of two things. If the DPP is choosing to discontinue at this stage, and his shock is that the DPP is discontinuing, somebody needs to bring the current AG into the light that the DPP has powers under the Constitution to discontinue. So the AG should not be shocked. The DPP is acting within the law.
Yeah.
If this current AG, Mr. Amor, is aware that the preliminary inquiry is about to start at the Magistrates Court in Port of Spain, and Mr. Gaspard is unable to produce his witness, and he's unable to say in what time frame he will be able to produce the witness, then the Magistrates Court is going to say, well, Mr. Gaspard, if it is you cannot offer a witness in this moment, then there is no case for this man, for these individuals to answer to. So Mr. Gaspard is saying, listen, rather than I put myself in any embarrassing situation where I have to answer to the court and give answers that create answers, so I am unable to furnish reasonable explanations as to why it is I cannot continue the prosecution, then it's the best thing to do is for him to withdraw. Yeah. Because the position Mr. Gaspard has found himself in is that Nelson is saying, I am not offering any evidence. I refuse to offer evidence. You cannot force me. If it is you choose to bring me before the court to offer evidence, I will simply indicate I'm not giving any evidence until the civil suit has been settled. Now, it is quite legal for Mr. Nelson to say, when I entered the agreement, the indemnity agreement, it was a condition that the indemnity arrangements be settled before I offer the evidence. And that is written and cast in stone and engraved in silver, and I have a document that speaks to that. So when it is you're refusing now to settle the indemnity arrangement, but you're asking me to offer the evidence before, I can simply say, well, that is not what this document that we signed said. The document says that you must put the horse before the cart. You can't put the cart before the horse.
And as far as you know, where does that matter reside now as to the handling of and the going forward with this indemnity arrangement? So the Attorney General who helped put it together is not the Attorney General now. At what point did this become the issue then? On what basis? As far as you know.
Well, it became an issue. We can't put a timeline on it because everything was just thrown on into the public space within the past week. Clearly, there's more in the mortar than the pestle. This thing would have been brewing for some time. All the parties concerned would have been well aware of the facts. The DPP would have been considering its position for a period of time before making a declaration in the courtroom, where he made the declaration in the courtroom where it should be made. He can't make it in advance of. Now, what it does is it places Mr. Alwari in a position where he must now defend his position. Why is that the indemnity arrangement was not settled? But this is not Mr. Alwari's fight to answer per se. It is the office of the Attorney General. He was merely an instrument of that office. So when it is being carried in the editorial that Mr. Alwari failed to fulfill the terms of the indemnity, it's not Alwari, it's the office of the Attorney General failed to do so. Now, it is still open to that office to indemnify and fulfill the terms of the indemnity arrangement at the High Court level. So you don't have to go to trial for that. So they can simply say that they're going to settle now.
It is your position then that on this matter there would have had to have been the discussions between Al-Rawi as former Attorney General and Amo as current Attorney General.
Well, there would be discussions between Al-Rawi and the Office of the Attorney General with regard to why it is the indemnity arrangement was not fulfilled with Mr. Nelson. When Mr. Al-Rawi, he was moved out of he was shifted, so to speak, by the Prime Minister out of the Office of the Attorney General, and he's now local government minister. When he shifted positions, the Office of the Attorney General now has to carry the mandate and responsibility to answer to why the indemnity arrangement wasn't fulfilled. Mr. Al-Rawi is simply a witness to what has happened. He's a witness because at the time he was then Attorney General, and he ought to have looked into the fact that the indemnity arrangement must be fulfilled or his obligations under that arrangement. When it is he left office, it would have fell on the Office of the Attorney General currently, meaning Mr. Amo. Mr. Amo and his office ought to answer to why it is that indemnity arrangement wasn't looked after or wasn't attended to in the absence of Mr. Al-Rawi when he demitted office. So Mr. Amo, in as much as he wants to distance himself from what is happening here, his office, if not him, his office must answer as to why when the baton was passed from Mr. Al-Rawi to him, why it is the Office of the Attorney General didn't act on the indemnity arrangement and now has placed the government in an embarrassing position, the DPP's office in a precarious position, and the Office of the Attorney General into question. So Mr. Amo is not, what discussions are taking place between Mr. Al-Rawi and Mr. Amo is something that none of us will be privy to. But if I was Mr. Al-Rawi and I was sitting in his position where he is now, I have nothing to answer to at this stage. I would have acted and done my part as Attorney General when I was sitting in office. And when I left, the responsibility lay on that office to carry the baton, to take up the mantle of the indemnity and to fulfill the obligations.
What do you think is the impact? What is the lessening of the responsibility on him to, I don't want to use the term come clean, but to come better? When he says that, well, I didn't do this on my own, I had advice from eminent senior counsel, and he called their names. What is that? How does that lessen the burden on him to explain the situation?
Right. Well, what he's basically stating is this was not any whimsical decision. It was not any ad hoc decision. I didn't just wake up a morning and feel like doing something. This is not Faris Al-Rawi making a decision to do something on my own. I got legal advice, and I sought legal advice from eminent senior counsel, well-respected people within the legal profession who are quite capable of offering legal advice. So, in other words, he didn't act on his own volition. A natural procedure would be to seek legal advice before one acts in a certain way. So if it is he's trying to exempt himself from having to answer to or any wrong or try to negate any allegations of wrongdoing on his part, he's simply saying, listen, we entered into an indemnity arrangement. That indemnity arrangement was an indemnity arrangement that the senior counsels advised me to enter into, to put it in writing, and they were part and parcel of the process in putting together that arrangement, in putting together the terms of the arrangement.
So were you in their position? Will you feel ill-circumstanced now by being brought into the limelight in this matter? Could they ask him, well, why did you feel you have to do that? So put our names in this. From a lot of quarters and at various levels in society, this is a mess, and you put us in that.
I'm shocked that Mr. Al-Rawi would want to reveal who the senior counsel were in relation to the advice that was given. The Office of the Director of Public Prosecutions would not indicate who were part and parcel of the arrangement. That should have been a courtroom situation. It would have been featured in the courtroom, and the indemnity agreement would have featured at the High Court level. Mr. Al-Rawi perhaps acted on his own volition in terms of revealing who the persons are. But if you're placed in a position where you're back against the wall and allegations are being raised against you that you are the author and finisher of this indemnity arrangement, he wants to say, listen, I didn't act on my own. So in drawing these men into the foray, he's not implicating them in any way. They didn't do anything wrong. They offered advice, and he wants to show, well, I got advice not just from some junior lawyer or somebody fresh out of the Hewling Law School. I got advice from people who occupy the upper echelons of the legal profession and who are very experienced attorneys. They are also, both of them are also senior counsel.
Yeah,
So,
right.
yes, in mentioning them, one may say, well, he ought not to have done that, but he hasn't done anything wrong. I'm just a bit surprised that he would feel it necessary to put into the public space who offer the advice. The public doesn't need to know that.
Our last question, the Prime Minister is reported in one of the papers today saying, well, this is not a matter for the Cabinet. How could it not be? So Cabinet ministers, members of the Cabinet go and make decisions and get involved in situations on behalf of the government and on behalf of the people of the country without others understanding that?
There is what we call pre-trial publicity. And you also don't want a member of your cabinet speaking on something that falls under the ambit of the Director of Public Prosecution's office. This matter is now before the court. It is what we call sub judice. So if it is myself and yourself and anybody in the public space, particularly in the cabinet, speaks or offers any opinion on this, they may be corrupting the minds and contaminating the minds of the general public. If it is this matter were to reach, meaning that Mr. Nelson offers the evidence now and it gets to the High Court level, a jury will have to be convened and the jury will have to make a determination as to the innocence or guilt of Mr. Ramdeen. So the Prime Minister is correct in saying that, that he's not making a pronouncement and nor his cabinet getting involved in terms of commenting in any way, because he doesn't want to contaminate the process.
The question is not whether they would comment on it or not, but to know from day to day on particularly major issues like these, this is what the colleagues are doing, this is what I'm doing, this is what he's doing. And so we have a sense of the activities of us as representatives of the people.
Right. Very correctly, he should not be making any input at all. Nor should he have his Attorney General make a comment, nor should he have his former Attorney General comment, because they are potentially witnesses to everything moving forward. So if it is, the question is along the lines of whether his office would comment or whether whether the cabinet, any member of the cabinet would want to
not to comment at all, but to have known some of what is now coming out, so that they had a sense as to how this action would have been taken in the first place against Messrs. Ramlogan and Ramdeen, so that the cabinet knows that this is what has happened and this is why. But because 90% of things that happen in the cabinet never make it into the public space. But when the Prime Minister says, well, this is not a matter for the cabinet, what he's saying is that, my interpretation of what he's saying is that, well, the Attorney General went and do that and he didn't have any responsibility to let it be known around the table that this is what we pursue in the public interest, in the people's interest.
Yeah. Let us not be naive. The cabinet would have been fully aware as to what the allegations were against Mr. Ramdeen and Mr. Ramlogan.
Precisely.
What the Prime Minister is doing is simply stating that if the Director of Public Prosecutions has a file in his possession and he has chosen to lay a charge, or the Prime Minister is stating if it is the Office of the Attorney General has information that somebody corruptly received money or is conspiring to defraud the state in some way, that they're going to breach some law in this country that is of a criminal nature, the cabinet is not getting involved. The Office of the Director of Public Prosecutions would have to receive a file from the TTPS, meaning the Commission of Police, or the required unit within the TTPS. So the chain of command would simply be the AG would have made a report to the TTPS, which is the Commission of Police. The Commission of Police would have conducted an investigation and sent the file to the DPP's office. The DPP office would make a decision whether there's enough evidence to lay a charge or not. So the cabinet in no way, or the government in no way, features in this process, nor if they were aware of facts surrounding this scenario, meaning that its Attorney General has information. It is clearly with the Attorney General's responsibility not to involve his cabinet more than let them know what this is. There's an issue arising here, but I'm sending the file, or I'm sending the police. I'm informing the police that they ought to investigate this situation.
Right, that's all I was asking. In other words, that's all I was trying to find out.
It doesn't look political. It doesn't look political at all.
Right. It's not that they were entirely in the dark until this matter now comes out. But thank you very much.
No, and he needs to act in that way to show that this is not politically motivated against these two opposition office holders.
Yeah. All right. Thank you very much.
He extracts the government out of the equation altogether.
We're going to leave it there. Thank you very much, Farid Ali, attorney. This has been 10 Questions. I'm Andy Johnson. Thanks for watching. We'll see you next time.